so help you God.
Yes, sir.
All right, we have Carter County case 27401. We have Johnson County case 24-CR-126. And we have a violation from Johnson County in 20 CR 45. Mr. Fletcher, first thing, you understand you have a right to have your hearing on the Johnson County cases to be conducted in Johnson County. My understanding is you wish to waive that right and ask that it be heard here today with all of the other cases.
Yes, sir.
It appears to be a plea agreement in these matters. We'll start with the Carter County case 27401. You've been handed a petition for acceptance of plea of guilty, waiver of rights. Is that your signature?
Yes, sir.
Did you read it or have it read to you?
Yes.
You understand that this document contains all of the rights that you would have during a jury trial.
Yes, sir.
You understand by signing this document, you're not only acknowledging these rights, but you're also acknowledging the fact that you're waiving or giving up each and every one of these rights in order for this court to accept your plea.
Yes, sir.
Count number 1 charges you with premeditated first-degree murder. That count is being dismissed by the state. Count number 2 originally charged you with first-degree murder and perpetration of a felony. That's being amended to second-degree murder. That is a Class A felony that carries not less than 30 years, no more than 60 years, and a fine of up to $50,000 or both. There's also a requirement pursuant to Tennessee Code Annotated 4035-501BB that the release eligibility date on that will be set at 100% service of the sentence. Count number 3 charges you with theft over $10,000 but less than $60,000. That is the C felony carrying not less than 3 or more than 15 years. A fine not to exceed $10,000 or both. And count number 4 charges you with escape. Escape is a Class E felony carrying not less than 1 or more than 6 years. A fine not to exceed $3,000 or both, and a requirement that be consecutive to any other sentence that you shall receive. With regard to the Johnson County case, which is 24-CR-126, and in the Johnson County case, I've received the same petition of acceptance of plea of guilty, waiver of rights. Is that your signature?
Yes, sir.
It's exactly the same form, only it covers the Johnson County cases. You understand that? Yes, sir.
Yes, sir.
You make sure you answer out loud, okay? They're gonna pick you up with that one.
In 24-CR-126, the Johnson County case, you're charged with tampering with evidence. It is a Class C felony, carries not less than 3 or more than 15 years, a fine of up to $10,000 or both. Count number 2 charges you with abuse of a corpse, which is a Class E felony, carries not less than 1 or more than 6 years, and a fine not to exceed $3,000 or both. And I'll address the violation of probation from Johnson County after we enter these pleas. You understand the allegation? You understand that you have a right to have a trial in these matters, and that would be a trial by jury. Do you understand?
Yes, sir.
In fact, yours is presently scheduled for May. You understand at such a trial, that jury would determine whether you're guilty or not guilty.
Yes, sir.
You understand that if you had gone to trial in this matter, you would have had the right to confront and cross-examine any witnesses that the state may have against you.
Yes, sir.
Understand you would also have the right to call witnesses in your own behalf, and if they would not voluntarily come to court, you could issue a subpoena and require them to come to court.
Yes, sir.
Understand that if you had gone to trial in this matter, you would have had the right to testify if that's what you wish to do, and no one could prevent you from testifying.
Yes, sir.
If you did not wish to testify, you understand that no one could force you to testify, nor could anyone call you as a witness.
Yes, sir.
Understand that if you had gone to trial in this matter, you would have had a separate trial for each one of your case numbers,
Yes, sir.
both here and in Johnson County.
Yes, sir.
You understand that any of those trials that a jury could have found you not guilty, where they could have found you guilty of a lesser included offense.
Yes, sir.
You understand if that would have happened, you could have received a lesser sentence than what you've agreed to.
Yes, sir.
Now, however, by entering these pleas, you understand that there will not be a trial of any kind in your cases, and the court is going to set a sentence for you as it is outlined in your plea agreement.
Yes, sir.
Mr. Fletcher, having advised you of all of these rights, do you hereby freely and voluntarily has anyone forced you to, threatened you, or promised you anything other than what's been stated in open court to make you do so?
No, sir.
There was a substantial amount of discovery in these cases. Started out in Johnson County, subsequently filed in this county, and the charges flipped in each county. Through all of that, do you feel like that you have been provided with all of the discovery in this matter, and that your attorneys both here and in Johnson County have provided you with all of the discovery, and you've had an opportunity to review it all?
Yes, sir.
And do you feel there's anything further your attorneys could have done for you at this point?
No, sir.
You understand that by entering this plea, you're not only giving up your right to a trial, but you're also giving up your right to an appeal in this matter, at least as to the issue of whether you are guilty or not guilty.
Yes, sir.
And you understand that you're under oath and you're being asked questions. If you answer any of these questions falsely, those answers could be used against you in a prosecution for perjury.
Yes, sir.
Mr. Fletcher, do you understand that your pleas of guilty in these matters are now the strongest evidence available against you? And by pleading guilty, you're stipulating or agreeing that there are facts to support your plea.
Yes, sir.
And you understand that these convictions can be used against you in the future to increase or enhance any punishment that you may receive should you be convicted of a crime in the future.
Yes, sir.
On the Carter County case 27401, count 1, the premeditated first-degree murder is being dismissed. Count number 2, you're pleading to the amended charge of second-degree murder. You're going to receive 35 years in the Tennessee Department of Corrections at 100%. No fine. You are taxed with the cost. The special conditions note that the sentence is out of range by plea agreement for the reduction from the first-degree murder charge. Jail credit begins from the time that you were booked into the Carter County Jail for the offense of escape, which is July 5, 2024. And that sentence will be ordered served, and it will be concurrent with Johnson County 20-CR-45 and the Carter County case 24535. Count number 3, on the theft of property of $10,000 or more but less than $60,000. You're going to receive a 3-year sentence as a standard 30% offender, $25 fine and cost, rendered infamous and must provide a DNA sample. That sentence is ordered served, and it is concurrent with count 2. Count 4, on the escape, you're going to receive a 1-year sentence as a standard 30% offender, $25 fine and cost. You'll be rendered infamous and must provide a DNA sample. That sentence is ordered served, and it is concurrent. It is consecutive to case 24535 on the escape. 24-CR-126. Now we're going to the Johnson County cases. In count number 1, the tampering with evidence, you're going to receive a 3-year sentence as a standard 30% offender, $25 fine and cost. You'll be rendered infamous and must provide a DNA sample. The special conditions note that the plea is entered in Carter County, and again restates when your jail credits begin running. Count number 2, on the abuse of a corpse, a 1-year sentence as a standard 30% offender, $25 fine and cost. You'll be rendered infamous and must provide a DNA sample. By agreement with the state, that sentence will be served and will be concurrent with count number 1.
I do want to make sure count number 1 on that, Your Honor, lists concurrent with Carter County 27401.
And count one does, state that it was concurrent with 2742.
Thank you.
Mr. Fletcher, do you understand what your sentences are going to be in all of these cases?
Yes, sir.
And on the violation, that will be ordered served, and that will be concurrent.
It will, Your Honor will note 27401 in Carter County, the concurrent language encompasses 20 CR 45 in Johnson County, which is that violation.
So your sentence is going to be 35 years, and the Department of Corrections at 100%. You understand that?
Yes, sir.
Do you have any questions about that?
No, sir.
Gentlemen, what's the factual basis for the plea?
Your Honor, if you can indulge me, I'm gonna take a little longer than I normally would. I spent considerable time last night preparing this, and it was out of the interest of the fact that I know from experience that in murder cases, the victim's family, the loved ones of the victim, they come for a trial as much to, almost to learn what happened, what proof is, as much as they want justice. And there's a lot of people over here that I've not ever talked to, and I'm trying to give them some idea of what a trial would have looked like to at least make up for that, because we don't get this with a plea. The end of Victor Birchfield's life occurred on June the 20th, 2024, but the story about his fate began much earlier and without him knowing anything about it. Billy Fletcher, this defendant, was serving out a short sentence in the Carter County Jail in 2024. That June, Fletcher had a parole hearing coming up, and he hoped to get word that he'd be released back to his home around Butler. But Cassidy Hyatt, the parole hearing officer that handled his hearing at the jail, recommended that his parole be put off for a year. This is something he did not want to hear. She told me that Mr. Fletcher acted polite throughout the hearing. It's all yes ma'am, no ma'am, nothing unusual. But unknowns to her, on recorded jail calls following the hearing, he was beyond distraught. His family, both his wife Brandy and his oldest son Thunder, on calls, tried to be positive with him, but he wouldn't have it. By the 19th of June, Fletcher was telling them to meet him at a location the next morning on the 20th, and Fletcher stressed that it was very important. He was told that he'd be met, but the proof would suggest that never happened. And as Brandy confided with me, she figured it was best to not do it, or else Fletcher would do something like jump in a car and take off. Fletcher had a trustee job washing cars at the jail, and that gave him some freedom of movement on the jail property. So on that morning of the 20th, instead of meeting family for whatever he was going to do, he just walked off the job. He took his identifiable jail shirt off, and surveillance cameras from 7:07 to 7:11 a.m. captured him walking north in the direction of the Watauga River, his only top covering being a white undershirt. Meanwhile, proof would show Victor Birchfield was parked in his Toyota 4Runner at a boat ramp area under an overpass on the other side of the Watauga, on Lover's Lane. Victor was a self-employed airplane mechanic who worked out of the Elizabethton Airport, and this being the summer, he tended to work a third shift. It was cooler. Cameras at the airport showed Victor driving off from work at 6:53 a.m., a mere less than 20 minutes before Mr. Fletcher walked off jail property. Proof would suggest he then traveled to Wendy's in Elizabethton to get a breakfast sandwich, and he was likely consuming that where Billy Fletcher found him during the escape soon thereafter. It was not immediately known to the Carter County Sheriff's Office that Fletcher had walked off, and it was not immediately known that anything had happened to Victor. Sometime later on the 20th, law enforcement in Johnson County were getting word from citizens that Fletcher was seen in their county. Those people knew he wasn't supposed to be there, he was supposed to be in jail. Johnson County then contacted Carter County, and the investigation into the escape commenced as Carter began scouring the prior jail calls of Fletcher that I've talked about, and trying to find video where he was. Meanwhile, later on the 20th, Tiffany Cole became concerned about her father Victor's whereabouts. He was supposed to have gone to a location on Volunteer Parkway to work on a car that day, but he never made it. He was not answering his cell phone. Tiffany even went to the extent of contacting local hospitals. No word. By the 21st, she reported him missing to the Sheriff's Department in Carter County, and a silver alert was issued. Trying to give authorities as much information as she could about his appearance, she retrieved a video from a porch camera of theirs which showed him in an orange t-shirt before he left for work the evening of the 19th. Part of the investigation into Victor's disappearance concerned the whereabouts of his forerunner. Law enforcement can get fast results from the new flock cameras which capture photos of tags on roads as vehicles pass by. The first flock camera that recorded Victor's forerunner on the 20th caught it at 9:04 a.m. on Highway 421, traveling into North Carolina toward Boone. More flock cameras caught it going through North Carolina. Eventually, by 2 p.m., it hit a camera between Clemson and Easley, South Carolina. Numerous other videos were obtained from stores, banks, and wherever authorities could find, showing the forerunner having traveled from Lover's Lane in Elizabethton at 7:53 a.m. until an 11:30 a.m. appearance at a Tiger Mart in Clemson, where Fletcher was reported on camera appearing to purchase cigarettes with what was Victor Birchfield's card. That transaction was declined, but an earlier camera at a BP in Asheville, North Carolina, caught Fletcher pumping gas and successfully using Victor's card for $52.54. Victor, however, was nowhere to be seen in any of the footage. Some days later, Tiffany's greatest fears were realized when Kevin Tyner, a South Carolina investigator, visited a hotspot convenience store in Greenville, South Carolina. His investigation had determined that a Greg Massey of South Carolina had dropped Fletcher off at a Walmart. Walking on foot from the Walmart, Fletcher had made his way to a hotspot convenience store where a camera captured him paying cash for a bottle of water. What struck Tiffany Cole, though, was she recognized possessions of her father on Fletcher's person. The hat he had on was her dad's, the sunglasses on top of the hat, and the backpack with the